attendees. Okay.
Okay. So, good morning and a warm welcome to everyone. Thank you for registering to our live Fichte Co webinar today. I hope that everyone is good, taking care of themselves and keeping safe during these uncertain times. By way of introduction, my name is Ifra George and I will be moderating today's webinar discussion. As we know, the UAE has declared more than 4,000 cases, and with the lockdown being implemented for an uncertain time frame, we have been receiving a lot of queries surrounding employment concerns in COVID-19. So we decided to conduct a webinar today to discuss some of your questions. Our main focus on today's webinar will be looking at the issues that an employee may face, to highlight the legal obligations an employer has, and to look at the rights available to both these parties. So to just give a brief overview regarding today's structure, the first half will be the English segment from 11 to 11:30 that will be presented by Dr. Laura Vora, our corporate associate. This will entail a short presentation regarding the new ministerial decisions, followed by a Q&A. The second half will be from 11:30 to 12, which will be our Arabic segment conducted by our senior litigator and associate Muaz Farawi, who will be discussing the measures implemented from a litigation standpoint. Please note that we have received a large number of inquiries and we might not be able to answer all the questions that have come in, so there will be a series of webinars in the upcoming future. With that, we thank you once again for taking the time out of your busy schedule and registering for this webinar. So without further ado, if I may welcome Dr. Laura to start off the English segment, and I shall pass on the screen to you.
Good morning, Ifra. Good morning, everyone. Thank you for taking your time, and thank you for joining our webinar today. It is our pleasure to be here. In order to proceed further, I hope that the presentation is correctly displayed on the screen. Can you kindly confirm?
Share.
Okay. So in order for us to proceed, indeed, we have received a large number of queries from our clients regarding this new environment. And as well, we have published consistent materials via our website, LinkedIn, and Twitter accounts that can always be checked. We hope that this is going to respond to part of your questions. However, we have decided to conduct this webinar in order to shed some more clarity on the Ministerial Resolution 279 of 2020 and the Early Leave Initiative there too. As everyone knows so far, obviously these initiatives apply only to the companies operating under the remit of the Ministry of Human Resources and Emiratization. And it makes no distinction as to if they are registered in a free zone or in the mainland. The only exempted entities would be in the private sector, the financial free zones that have, as everyone knows, their own regulation. We would like to highlight two main points with this webinar. Number one, the fact that this environment created by the package resolution plus the early leave initiative does not represent a golden opportunity for employers willing to, let's say, unilaterally cut off staff during this period. So from this point of view, we would assess that both the resolution and the early leave act more as a deterrent, not as a facilitator. And on a second note, we would like to highlight the fact that it has a generational impact, and it's going to have an impact in the employment-related market from now on, with all the consequences that derive from here. New HR policies, new contracts in place, etc., as we are going to see towards the end of this presentation. Now, moving forward, everyone knows that the measures that need to be implemented so far are to be taken gradually. By this, we assess that, let's say, an employer being in rush to terminate staff to make them redundant without exhausting previous measures would be likely to face a valid employment complaint. So this being said, the measures are the work from home, the paid and unpaid leaves, and as well the salary reduction, either temporary or permanent. And the new measure is added now with this early leave initiative, where an employer would be able to repatriate staff in order to cut costs, and obviously at the cost of a flight ticket and at the cost of keeping their employment contracts valid. Now, from our point of view as lawyers, a very important distinction that this package has brought into the scene is a form of recognition of this concept of redundancy. We know that the concept of redundancy is relatively having a struggled existence in the classical UAE legal system. But this resolution made it quite clear that unilateral terminations without the form of compensation are not possible, even if they're happening for a cutting cost reason. And that's what redundancy is all about. Now, from a legal and as well compliance and financial perspective, the resolution has made available to the employer, two routes. Number one, the redundancy route, meaning that the employees are being kept on the visa on the employer, being paid their allowances and placed in the virtual labor market. And let's say a more cost-effective route, the early leave, which means that the employer can actually repatriate part of their staff at the cost of a flight ticket under the condition of keeping their employment contracts up and running. So what is the difference from our point of view in between these two measures, aside from the cost impact, which is very visible? Yeah, in the case of redundancy, the employment contracts actually remain in full force and effect unless the employee has managed to secure employment elsewhere, whereas therefore consequently they'll be terminated. Whereas in the case of the early leave initiative, the employment contract remains without doubt full and valid throughout the whole period, throughout this temporary period. So now moving forward, what we are trying to highlight is the fact that the purpose, the aim of this new form of regulation is to protect the labor market, to protect the employees against, let's say, markets overreacting and employers trying to cover marginal costs at the account of the employees. Further on, this period, which is obviously not easy for anyone, has created a lot of myths, and some of these myths need to be debunked because not all of them are legally valid. So as we know, all the measures need to be documented. When we discuss about documented measures, we imply amendments to the employment contracts being signed, forms of agreements that can exist in between the employer and the employee. Nevertheless, the resolution comes with an annexure. It has drafts of contracts, templates of contracts that can be entered into by the employer and the employee. And then one question that appears is the WPS sanctions from the mainland companies that operate under the WPS platform. Well, it is very easily understandable that an employer who took the measures gradually as prescribed by this new package, resolution and early leave, would be very easily in the position to document why, let's say, the level of wages transferred in a month are lower or non-existent in comparison to the initially registered wages in the Ministry of Labor, therefore in the WPS. So everything depends on how compliant the documentation produced by the employer is in that situation. And then we've received many questions from clients asking whether an employer needs to officially demonstrate that they have been financially affected by this situation. Well, it is true that directly or indirectly, the full market has been affected, but what one needs to bear in mind is the fact that the the effect of these measures acts indiscriminately. So we cannot say that all sectors are equally affected. So in this situation, us as lawyers, we would emphasize that indeed when an employer faces an employment claim with a drastic and probably undocumented reduction of salaries, he or she would be in the position to demonstrate and would be probably required to demonstrate in a court of law why these measures have been taken or how they are justified from a business or financial perspective. Equally, we emphasize that the aim of this resolution is going into the same direction, because we know very well that when an employer wants to apply a permanent reduction of salaries, this needs to be approved and submitted to the Ministry of Labor. The Ministry of Labor has very well the ability to ask the employer for justification as to the proportionality of these measures comparing to the financial loss or the impact, the business impact suffered by the respective establishment. So obviously we cannot assume that generally there's no official proof that the employer needs to make. Moving forward, another point that has been brought to our attention is that employers that refuse to comply with these precautionary measures implemented by the employers would be terminated or can be terminated. Whereas the text of the resolution is silent in these matters, there are other jurisdictions such as the KSA, the Kingdom of Saudi Arabia, that officially confirm that employees refusing to comply with these measures can be terminated. In UAE, we have received several confirmations from the Ministry of Labor, but the main idea that we are trying to highlight in here is that termination still remain possible in this period because the employment law itself remains possible. And in such a situation, for for a rejecting employee, an employer would have at all times the ability to make a defense and actually prove that the measures taken are reasonable and refused by that respective employee. Therefore, again, on a contingency basis, on a case-by-case basis, we would need to highlight the point that yes, such employees may be terminated. A very important point is a natural right for everyone. Nobody is exempt from litigation in this period. And as it applies for employers, it applies for employees as well. We know very well that the immigration authorities have exempted the visas cancellation and have actually expanded the availability of these visas until the end of the year. But this wouldn't mean, let's say, that an employee in a situation of not willing to come back to work after an early leave would be exempt from claims. No, at that point, the employer has the full array of statutory remedies against that employee, starting with warnings, terminations, or even more severe actions, which we are, let's say, forecasting to see in the future, such as absconding. So nobody's actually protected from such claims. All in all, what we are trying to highlight is the fact that the employment law, the federal law number 8 of 1980, remains applicable and is not superseded and not in a way amended drastically by these resolutions. And that would be a very important point to make, because during this situation, the termination provisions for lawful, unlawful termination, limited, unlimited contracts would definitely remain valid. So in this full corundum of questions, yeah, there are a few important points that remain valid throughout the full span of this period for both the employer and the employee. And in here would highlight the fact that these precautionary measures that can be adopted by the employers pursuant to this package account or can be or should be counted for the calculation of the end of service benefits. And the rationale behind that is that the measure is of a temporary nature. And obviously at the end of this period of implementation, the employment contract would need to go back to its pre-existing stage. At the same time, our salient advice would be that employers and employees to be generous and lenient with each other. For instance, although let's say, the personal liabilities of an employee are not the responsibility of the employer, such as bank loans, for instance, in any way. It is advisable for the employers to help, to support, because obviously the negotiating power of a sole individual against a bank creditor should be or can be extremely limited. At the same time, we would highlight the fact that the employees are not fully protected from termination. As we said, the cases of termination made in compliance with the employment law or with this resolution remain valid. And the only point that this package tries to bring at the new level of, let's say, a legal dogma is the fact that an unilateral termination without the form of compensation cannot exist. So in order to, let's say, bring even more stability to the employment market for an employee, it's very important to know that, upon applying for early leave, it's very unlikely for an employer to have the possibility to reject this opportunity for the employee for various reasons. First of all, it's nowadays almost statutory mechanism, and secondly, it's much cheaper for an employer to, let's say, place the employees in, to repatriate the employees temporarily and bring them back afterwards. To conclude with our presentation, this is not the only regulation package that appears in this scene. There will be others aimed at implementing probably this resolution as well as the recovery process. And what is very important for everyone to understand is that the unavailability of a qualified workforce into the market post these prevention measures can seriously hinder the process of recovery, or making it even futile in such situations, knowing that in this period there will be a number of companies forced to exit the market. And for us as lawyers, we have already received a number of requests for bankruptcy at the account of impossibility of paying wages. So we are expecting these claims or this kind of cases to be in the rise in the upcoming period. But what is very important for everyone to know is that this period or this package, this resolution, is not an inflation hedge for an employer, but on the contrary, it is a time when the security of employment is to be paramount to respond, to build contingency plan, and so on. So from our point of view as lawyers, this new legal background represents a new compliance requirement that needs to be treated quite carefully, not to mention the reputational damage that poorly implemented measures would bring into the business environment in the long run. So this being said, of course, we can, as lawyers, we usually do, and we amend contracts, we work on the legal matters related to employment there too. But for us, the most important task in this period is to balance and to mitigate the risk of litigation, and obviously the risk of turnover or of losing employment. So from our point of view, these two variables, the turnover cost as well as the litigation cost, are going to be the two main factors, the two main thresholds that are going to force businesses out of the market. Obviously, the world is in more or less a situation of a digital divide, given that not all companies have the ability to work remotely and not all business sectors. Therefore, in these uncertain times, we estimate the risk of litigation remains. It is systemic, it is asymmetrical. We don't know where exactly in which sectors it's going to hit, but it remains there. For us as lawyers, we cannot issue a legal advice fitting all situations, because that's not possible. So we prefer to handle these things on a case-by-case basis contingently. So hoping that this initial presentation was helpful, I'd like to thank everyone once again. I'll pass it on to Ifra for the Q&A session.
Thank you, Laura, for the presentation. There are definitely valid key points that you've mentioned, especially highlighting the fact that the labor claims are not exempted during this period. So we're now going to start the question A section for this part. So the first question that I can see says, will the employer be liable to pay notice period salary in the current situation for those who are outside the country and are unable to come back in the future?
Thank you for the question, Ifra. I think that this is a very good question. How can we respond to that? So basically, it depends on the reason that that person is outside the country, probably on annual leave or probably as for a business trip. Obviously, the impossibility to return is extraneous to him because it's a governmentally imposed measure. And definitely notice periods would need to be paid in this situation. But my question would be further, the notice period salary is paid usually in a case of termination. Therefore, it would be interesting to assess the reason for that termination, whereas the employees outside the country, is it lawful, unlawful, and the likes. But unless it is one of the cases where are statutorily exempted from this notice period payment, say, for instance, Article 120 from the employment law, then definitely the notice period salary would need to be paid. So hopefully I have responded to the query, and I'll pass it back to you, please.
Thank you, Laura, for clarifying that. So we've got another question that's just come in. It says, is mutual consent required between the parties for a payment reduction?
Yes, it is required. It's actually a stringent need to have that documented. And in here, in order to respond, I would highlight the two situations that exist, a temporary salary reduction as well as a permanent salary reduction. In the first case, obviously the amendment to the employment contract needs to exist, and it needs to be kept available at the premises that in the establishment for, let's say, for eventual inspections from the Ministry of Labour. But in the second case, for the permanent salary reduction, it is mandatory to submit these amendments to the approval of the Ministry of Labour. So in this more stringent measure, obviously the compliance requirements are much higher. So to respond to the question, to wrap up, yes, the consent made in writing would be needed.
Thank you, Laura, for clarifying that. It was very useful. We've got one more question that's come in, which says, can employees be instructed to forego a part of their annual leave?
Yeah, that's quite a common question that we have received these days. It is already mentioned in the Federal Law number 8 of 1980 as amended that the employer has the ability to direct the employees or determine the duration of the annual leave of the employees as per Article 72. So therefore, to respond to this query in this particular context, yes, it is possible for the employers to direct these employees or to ask them to pursue their annual leave.
Thank you, Laura, for that. So one more question that has come in. So we're just going to start with the Arabic segment soon. So I'm just going to finish off with one final more question for you. What can companies do to make sure that there is less impact on their business and on employees with the current situations of the COVID-19 crisis?
It's a very good question, quite comprehensive. The discussion can be very long, and we can discuss on a variety of matters. But obviously, the legal part of a business needs to be regarded in its due relation in the overall spectrum of that business. So it cannot be looked at singularly. Obviously, whereas we need to integrate the legal part with the finance, with the business culture, with decentralization, I would limit this response for obviously time constraints to the legal part. So from our point of view as lawyers, what we can say is that it's very important to have compliant HR standards in place. It is very important to have sound employment contracts, correctly amended, correctly communicated to the regulators, to the Ministry of Labour. It is very important to have a legal strategy for mitigating, let's say, the litigation risk, for mitigating the turnover costs, so employees leaving the organization. In here, turnover has a very high cost due to the visa requirements and the likes. Therefore, I would apply a little bit of each, and obviously the strategy overall needs to be integrated. And in terms of legal work, that would imply, let's say, a lot of advisory, a lot of due diligence, compliance work, and the likes. But in the end, it's a beautiful domain and it's doable. So hopefully, I managed to respond.
Thank you, Laura, for that. We just got a few more minutes, so I'm just going to ask you one more question, if that's okay with you.
Yes, please.
So as per the government notification, can an employer who has already signed a contractual agreement with a new employee who is awaiting issuance of a visa, which is currently on hold, ask the employee to take a cut in the salary already agreed in the agreement executed between the two?
Oh, yeah, that's quite an interesting question. Thank you for that, Ephraim. So how do we understand this situation legally? So the employer and the employee have entered into the employment contract, and this employment contract has been probably signed and registered. However, the visa is on hold due to these governmentally imposed measures in this situation. The advice that we give as lawyers is that the employment contract and the visa in this situation need to be regarded as two separate matters. So from a legal perspective, the relationship between the employer and the employee is born at the time that they sign the contract, and this contract is registered in the Ministry of Labor for opposability purposes. So at the time that this contract is in place, then definitely the employee is the employee of that employer, and therefore can be subject to the allowable measures under Resolution 279, including salary reduction. We would highlight here something extra, the fact that usually at the beginning of employment, employees are on probation. And I don't know the situation of this employer per se. It can be or it cannot be a probation. However, for employees on probation, the situation is a little bit more sophisticated, given the fact that in the probation period, the employment contract can be terminated without a notice. So,
thank you.
Yeah, that would be my answer. Hopefully,
Yes,
we have managed to respond.
Much appreciated, Laura. So now we shall begin the Arabic segment of the webinar. And if you please welcome me in joining Muaz Farawi, and I shall pass the screen to you whenever you are ready.
Thank you, Ifra. بسم الله الرحمن الرحيم وبه نستعين والصلاة والسلام على أشرف خلق الله أجمعين. نتمنى في البداية إنه الجميع يكونوا بخير وصحة، ونقول إنه مواجهة الظروف الحالية هي مسؤولية مجتمعية لكل المجتمع، فنحن لازم نتعاون ونتكاتف عشان نمر بالفترة الحالية إلى بر الأمان. طبعا كل العالم بيسأل إنه الإجراءات الاحترازية المتخذة من جميع الدول حتأثر بالضرورة على كل الالتزامات التعاقدية بما فيها العلاقة التعاقدية بين صاحب العمل والعامل. فشاكرين لوزارة الموارد البشرية والتوطين بالدولة الإمارات العربية المتحدة إنها سارعت باتخاذ إجراءات احترازية مضمونة بضمانات معينة بموجب القرار الوزاري 279/2020 الصادر بتاريخ 26/3/2020. فبنتني على القرار الوزاري وبنقول إنه وفق في اختيار الصياغة القانونية المناسبة، لأنه وضع الالتزام بين الطرفين، بين صاحب العمل والعامل، في المحافظة على مصلحة الطرفين. فاستخدم كلمة التوافق مع العامل بين صاحب العمل لمجابهة الظروف الحالية. فالالتزام بالقرار ينطبق مش على كل المنشآت في الدولة، ينطبق على المنشآت المتأثرة ماليا خلال فترة الإجراءات الاحترازية. يتمثل الالتزام في التوافق بين الطرفين، يعني نحن ما بنضع العبء فقط على صاحب العمل أو العبء على العامل، لازم يتوافقوا لأنه دي ظروف استثنائية، لازم الطرفين يتفقوا فيما بينهما عشان يصلوا لحل يرضي جميع الأطراف. في المحافظة على حقوق صاحب العمل، في المحافظة على حقوق العامل. فالقرار الوزاري وضع 4 شروط بالتدرج، لازم ننتبه من كلمة التدرج. أولا، جميعنا نعرف إنه الآن إحنا شغالين من المنزل، نظام العمل عن بعد. بنحاول إنه قدر الإمكان إنه نوفر قدر كافي من العمل، يكون العمل ماشي بصورة طبيعية، طبعا بالاتفاق مع صاحب العمل. الخطوة الثانية تدرجيا برضو بالاتفاق تكون إجازة مدفوعة الأجر، أو إجازة بعد ذاك لاحقا بدون أجر. فيما يتعلق بالإجازة بدون أجر، لازم يتم توقيع نموذج عقد العمل المؤقت الملحق اللي أصدرته الوزارة، موجود هو على الويب سايت مال الوزارة، ممكن الناس تطلع عليه. يتوقع بين الطرفين عشان يكون ثابت الاتفاق بين الطرفين. فإذا العامل حيروح على إجازة بدون أجر، لازم يثبت موافقته بالتوقيع، ولازم يتنصف في الملحق تحديد مدة الإجازة بدون أجر، وحجز تذكرة سفر للعامل بواسطة صاحب العمل. تاليا إنه العلاقة العمالية الناشئة وفقا للعقد الأصلي بتستمر إلى انتهاء المدة المحددة في العقد، وممكن تتمدد. ده الشيء الأول. الشيء الثاني، إذا اضطرينا نروح أبعد من كده لتخفيض الأجر بصورة مؤقتة أو بصورة دائمة، برضو لازم نوقع على عقد عمل مؤقت وفقا للنموذج المعد، ويحتفظ العامل وصاحب العمل بنسخة من كل العقود. كل الناس الآن بتسأل إنه إذا في عدم اتفاق بين صاحب العمل والعامل، شو يكون الإجراء المتبع قانونا؟ كيف يستطيع صاحب العمل مجابهة الظرف الحالي في الإجراءات الاحترازية في ظل المنشآت مسكرة والمنشآت الحكومية مسكرة؟ فلازم العمل يتأثر بالإجراءات دي. فإذا في اتفاق من العامل، أو نقول توافق، نستخدم نفس الصيغة اللي استخدمها القرار الوزاري، إذا في توافق بين الطرفين ما في مشكلة. المشكلة بتظهر إذا ما في توافق على أي من الخيارات اللي وضعها القرار الوزاري، اللي هي العمل عن بعد، الإجازة براتب، الإجازة بدون راتب، خفض الراتب مؤقتا أو بصورة دائمة. إذا رفض العامل، كل الناس الآن بتسأل هل أنا عندي الحق إنه أرفض؟ نحن ما بننصح إنه يكون في رفض من جهة العامل. ليش؟ لأنه زي ما قلنا هي مسؤولية مجتمعية بتقع على الجميع. لازم نتعاون كموظفين، كأرباب عمل، نتعامل بالاتفاق فيما بيننا عشان نواجه الظرف الحالي اللي هو نعتبره ظرف استثنائي. فما بننصح إنه يكون في أي فصل للعامل، وما بننصح إنه العامل يرفض اتخاذ أي من الإجراءات النص على القرار الوزاري. لكن من وجهة النظر القانونية نحن بنعتبر إنه ما في قانون بيقدر يلزم صاحب العمل إنه يتحمل خسارة ناتجة عن ظرف طارئ، عن حالة استثنائية، لأن القانون في هذه الأحوال بيضمن حقوق الطرفين، بيضمن حقوق صاحب العمل، بيضمن حقوق العامل. فإذا رفض العامل فحيكون صاحب العمل ما عنده أي خيار سوى إنهاء العقد من طرف واحد. فطبعا إنهاء العقد بيختلف سواء كان العقد محدد المدة أو غير محدد المدة، ويبغى الإجراءات المنصوص عليها في قانون العمل. بنقول إنه قانون العمل بنص على بطلان كل شرط بخالف أحكام قانون العمل ما لم يكن أكثر فائدة للعامل. فالفكرة القانونية من قانون العمل هي حماية حقوق العمال والموظفين من التعسف. بنكرر المسألة دي ليش؟ لأنها مهمة. فلازم يكون الاتفاق أو التوافق مع العامل كتابة عشان يثبت حقوق الطرفين. فعرض العمل عن بعد يكون كتابة، رد العامل يكون كتابة، عرض الإجازة براتب يكون كتابة، رفض أو موافقة العامل تكون كتابة، عشان كل شيء يكون على بينة. إذا حصل نزاع لا قدر الله إنه الناس تقدر تحفظ حقوق كل منها. بنعتقد إنه إذا تم فصل العامل بناء على رفضه في ظل تأثر المنشأة بالإجراءات الاحترازية الحالية، فما بيكون الفصل تعسفي. ليش؟ أولاً عبء الإثبات بيقع على العامل، عبء الإثبات قانوناً بيقع على العامل لإثبات إنه الفصل تم تعسفياً. هل يجبر القانون رب العمل على تحمل رواتب وأجور وبدلات في ظل الأحوال الحالية؟ الإجابة من وجهة نظر قانونية لا. في نظرية في القانون اسمها نظرية الظروف الطارئة، اللي هي بتنص على إنه إذا طرأت حوادث استثنائية عامة، لازم تكون عامة، لم يكن في الوسع توقعها وترتب على حدوثها أن الالتزام التعاقدي وإن لم يصبح مستحيلا صار مرهقا للمدين اللي هو صاحب العمل. فهنا نحن في ظل الظروف الحالية لازم يكون في إرهاق لصاحب العمل في سداد الأجور والمرتبات. فعشان كده بنوصي فقط بالتوافق بين الطرفين. نحن عارفين إنه حالات الفصل المحددة لصاحب العمل منصوص عليها في قانون العمل بصورة محددة 10 حالات، وإنه عبء الإثبات بيقع على العامل إنه أنا اتصلت مع العمل تعسفيا. فعقد العمل ينتهي إذا اتفق الطرفين على انتهاء العقد، أو إذا انتهت المدة المحددة في العقد، أو إذا بناء على إرادة أحد الطرفين في عقود العمل غير المحددة، بشرط الالتزام طبعا بفترة الإنذار والأسباب المشروعة للعقد دون تعسف. وإذا كان عقد العمل محدد المدة وقام صاحب العمل بإنهاء العقد لغير الأسباب المنصوص عليها في المادة المذكورة اللي هي 120 اللي هي ال10 حالات المحدودة حصرا، في هذه الحالة يلزم صاحب العمل بتعويض العامل عن الفصل التعسفي، بشرط أن يثبت العامل إنه فصله كان لغير سبب مشروع. في هذه الحالة مبلغ التعويض القانون حط خيارين، إنه لا تجاوز مجموع أجر العامل عن فترة 3 شهور أو المدة المتبقية من العقد أيهما أقصر. ففسخ العمل في عقد العمل المحدد المدة بيجوز لكل الطرفين إنهاؤه برضه وفقا لأسباب مشروعة في أي وقت لاحق لانعقاده، بشرط الإنذار خلال 30 يوم قبل الانتهاء. فجميع الأسئلة اللي وصلتنا بتنحصر في إنه هل في حال رفض العامل يجوز لصاحب العمل إنهاء العقد؟ زي ما قلنا ما بنوصي بإنهاء العقد، وبنوصي بإنه الطرفين يتوافقوا، لكن إذا اضطر صاحب العمل في ظل رفض العامل ما بنعتقد إنه في تعسف، بس يكون صاحب العمل بيتعامل مستنديا، يحفظ كل شيء مستند، يبلغ مكتب العمل بكل إجراء اتخذه، ويا حبذا تكون موافقة أو رفض العامل مكتوبة لأي من الخيارات لأي من الخيارات المنصوصة في القرار الوزاري. إذا حصل نزاع واضطر الطرفين يلجوا إلى المحكمة لاحقا لا قدر الله، فيكون صاحب العمل عنده دفع اللي هو الظروف الاستثنائية الطارئة، اللي هو بيعتبر القانون عذر مقبول لتحديد وضع الإخلال بالالتزام في الموازنة بين مصلحة الطرفين. زي ما قلنا نوصي بالتوافق، بنعيد وبنكرر التوافق بين الطرفين، ما بنوصي إنه يكون في رفض من جهة العامل أو تعسف من صاحب العمل. الناس تحاول مع بعض تشتغل إنه نطلع لبر الأمان في هذه احاول ارد على بعض الاسئله. طيب، وردنا سؤال بيقول اذا اتخذ صاحب العمل قرار بتخفيض راتب الموظفين بالشركه بناء على القرار الوزاري رقم 297 لا يجوز اتخاذ قرار بصوره منفرده. هذه في البدايه. السؤال صيغته انه صاحب العمل بيسال اذا صاحب العمل اتخذ قرار. بدايه بنقول لا يجوز اتخاذ قرار بصوره منفرده من قبل صاحب العمل. فنؤكد لازم يكون في توافق بين الطرفين. فصيغه السؤال بتدل على انه صاحب العمل بفهم القرار الوزاري انه بيحتيه الحق انه ياخذ قرار. لا، قرار بصوره منفرده بيحملك مسؤوليه الدخول في نطاق الفصل التعسفي. لازم نتعاون ونتوافق مع بعض، يكون اي قرار حيتخذ بالاتفاق بين الطرفين. فاذا رفض العامل، واللي هو من حقه يرفض طبعا، ما في نص بيقول انه لا هو لازم يقبل، من حقه يرفض. ف نوصي العمال والموظفين جميعا بالتعاون والتوافق مع اصحاب العمل وارباب العمل. ليش؟ لانه ده ظرف استثنائي بقى علينا كلنا، ومسؤوليه مكافحته ومجابهته مسؤوليه بتقع على الجميع. فبنوصي من وجهه نظر قانونيه انه العامل ما يتعسف في الرفض. فالسؤال الثالث في حاله الرفض، هل اقوم بانهاء خدماته؟ زي ما قلنا ما بنوصي بانهاء الخدمات، لكن اذا اصبحت المنشاه تتحمل عبء وخسارات ناتجه عن هذه الفتره او الاجراءات الاحترازيه، فبالتالي ما في خيار امام صاحب العمل غير انه يفصل العامل، بشرط تثبت انه المنشاه متاثره بالاجراءات، في خسائر ماليه، رفض العامل الانصياع لاي من الخيارات الخمسه. الاثبات المفروض يكون كتابه، فيكون كل التعاملات كتابه. بنوصي اصحاب العمل قبل ما تتخذ اي قرار بشان العمال التابعين لك، يتشاور مع محاميك فيما يتعلق بصياغه الرسائل بين صاحب العمل والعامل، لانه اذا في اي خطا في الصياغه ممكن تتفسر هذه الاخطاء في الصياغه لغير صاحب العمل. ف في سؤال بيقول اذا رفع العامل دعوى مطالبه بفصل تعسفي بناء على رفضه، هل سوف تحكم له المحكمه؟ زي ما قلنا ان احنا ممكن صاحب العمل يستفيد من العذر المقبول اللي هو بيتمثل في الظروف الاستثنائيه الطارئه، وده عذر مقبول قانونا. المحكمه تتدخل في هذه الحاله وترد الالتزام المرهق للحد المعقول وفي الموازنه بين مصلحه الطرفين. زي ما قلنا عبء الاثبات بقى على العامل انه سبب الفصل كان تعسفي. ما نعتقد انه في عامل ممكن يثبت انه الفصل في ظل الظروف الحاليه وبناء على رفضه الانصياع لاي من الخيارات الموضوعه في القرار الوزاري ممكن يثبت بعد كذا انه الفصل كان تعسفي. ما نعتقد، يعني في الممارسه العمليه صعب يكون العامل قادر على اثبات انه الفصل تم بتعسف او بدون اسباب جديه او غير مبرر، لانه زي ما قلنا الظرف الحالي بقى على الجميع بدون استثناء، كل الجميع حيتاثر به. الخروج الى بر الامان مسؤوليه الجميع، صاحب العمل والعامل. لازم الناس تتوافق، تتفق، تشوف اقل الخسائر بين الطرفين وتمشي عليها. اعتقد انا غطيت كل الاسئله الان، وحرجعكم لزميلتي افرا.
Yes.
Yes. My with you.
Okay. Thank you so much, Moaz, for that. So we're nearing today the end of our session, but in summary, just to highlight the key points as to overall what has been discussed within the past hour. We've talked about the Ministerial Resolution 279 regarding its scope and applicability. We have provided clarity towards the measures implemented as per the resolution, and we've also discussed the rights and obligations of the employee and employer during this period and what they can do to protect themselves in order to avoid any dispute in the future. So I do want to thank both Dr. Laura and Muaz for presenting today. As informed in the beginning of the webinar that due to the time constraints, we were not able to answer all the queries. However, we will be conducting future webinars on similar topics to answer your questions. With that being said, you can also send your questions to our info mail, which is info@fichtelegal.com. Now, before I say goodbye, I would just like to pass the screen one last time back to Dr. Laura just to give a few final remarks regarding today's session. So, Laura. Laura, is the screen with you?
The microphone.
Laura.
Thank you, Ifra. Thank you once again for this, and thank you, Muaz, for the insightful presentation. I think that that's very useful for everyone. Indeed, we will keep publishing material online on our website as well as through our different social media channels, and our intention is to conduct a series of webinars. We will have a web series conducted in order to address not only employment issues, but other issues such as contracts, digital signature, automation in business and the likes, which are going to be extremely useful in this period and in the period to follow in the recovery phase. Now, since we have a few minutes left, I would like to take a couple of more questions from the public and respond to those. Someone is asking whether we are going to share our presentation to the participants in Arabic and English. Yes, we'll definitely do that. We are going to have a follow-up on this webinar, as well as would have additional fruitful webinars to look into. Please stay tuned and look at our website and, as said, social media packages to get more information about the legal updates in this situation for employment and not only. Another question that I see on my screen is what are the options for an employee that doesn't consent to the temporary reduction proposed by the employer? This is a matter that we have touched in a way in our presentation. To share more clarity on this particular point, the employer and the employee are supposed to enter into this contractual relationship on equal footings. So sooner or later, each and every of them is a debtor to the other. So in this situation, looking back into the theory of contracts, we cannot assume that an employee can unilaterally refuse to have his salary reduced without having a consequence for that. So as we already said, in certain jurisdictions, say Kingdom of Saudi Arabia, it was made very clear by the Ministry of Labor there that the employee facing such a situation would be terminated. In UAE, it is expected that the same path would be followed. But one more thing that I would like to highlight is the fact that these measures need to be properly documented and properly implemented. Because we cannot simply say to an employee, you're fired, and expect that employee not to come back with the claim or with the query and the likes. So all in all, it is not recommendable for an employee to reject or to refuse to have these measures applied, given that this situation affects everyone. The employer and the employee are both in the same situation. They are all in this together, and everyone is expected to cope one way or the other. Hoping that this was a satisfactory answer. We would move to the next question, which is, can employers file for bankruptcy if they are not able to meet their liabilities, their labor liabilities? Yes, it is possible to file for bankruptcy. Let's remember that according to the bankruptcy law and the sectorial legislation applicable, the employee is actually a creditor of the employer regarding the obligation to have their salary paid. Therefore, yes, it is possible, but it is very important for everybody to know that bankruptcy is a court-associated process, and being a court-associated process, it needs to follow the procedure prescribed by the bankruptcy law, meaning the composition procedure, the, let's say, impossibility to cover expenses for a certain period of time, a certain level of liabilities, let's say exceeding 100,000 dirhams in order to be able to file for this bankruptcy. And a very important point to be made in here is that, let's say, a certain employer willing to file for bankruptcy would need to give a guarantee of minimum 20% liquidity on his debts. Therefore, it's not that easy, and it doesn't necessarily take away the liabilities from the employer. In the end, it is a judge, after the vote of 2/3 of the creditors, who is going to assess whether the company is bankrupt or not, or if it is in the position to meet the liabilities or not. So the process is not that simple, yeah? Subject to litigation and the likes. Okay, moving forward to another question. How the end of service will be calculated vis-a-vis the temporary measures? We've said already that the temporary measures in principle do not affect the calculation of end of service benefits, or are being accounted for the calculation of end of service benefits. How do we understand that? Obviously, if, let's say, an employee is working from home, working remotely, yeah, if this measure is implemented, definitely that employee is going to be paid. Therefore, there's no reason to look into the end of service calculation. Now, for annual leave, again, there's no discussion. Yeah? End of service would follow the statutory route, which is the contract agreed and registered by the employer and the employee in the Ministry of Labor. If the salary is being reduced temporarily, the same. Yeah, it is expected that post this reduction, the salary to come back to its initial stage. Therefore, the period that the employee has spent in this probation time, in this temporary precautionary time, yeah, to be accounted as months that are being spent in the service of the employer, therefore accounted for the calculation of end of service gratuity. Now, equally, if an employee is on an early leave situation, yeah, the communication actually from the Ministry of Labor specifies expressly that the employment contract remains in full force and effect, and this temporary period when the employee has been outside the country is going to be calculated, accounted for gratuity pay and other statutory dues to the employee. And it's not randomly that I left this last scenario now, which is the permanent reduction of the salaries. In here, the discussion can be a little bit more comprehensive, and actually the Ministry of Labor itself is probably expected to grant some more clarification. Because obviously we know that if the salaries are being reduced permanently, this is going to be subject to the Ministry of Labor approval. And whereas, let's say, an employer willing to undertake this measure is going to apply for the measures for a reduction in the Ministry of Labor, the Ministry of Labor can come and request very easily that the end of service accrued prior to these preventive measures being applied to be paid at the levels of, let's say, basic salaries that existed prior to these COVID-19 precautionary measures to be implemented. All in all, obviously, even if their salaries are going to be permanently reduced, Now, it is expected that obviously these periods of time prior and after the precautionary measures to be obviously accounted for the calculation of the end of service. Okay, I see no further questions. So as my colleague Ifra said, in case of any other questions, please address them via our social media channels or via email to our info address, info@fichtelegal.com. I'd like to thank everyone for joining. Thank you for your time. I sincerely hope that that you have found this information useful. I sincerely hope that everyone stays safe and that we are able to pass this period in good terms. And hopefully when the recovery period is in place, we'll discover new business trends and definitely maybe a better business environment than before. Thank you and all the best for everyone.
Thank you, Laura, for the closing remarks. So with that, I would like to end today's session. I hope that everyone stays safe, and please do stay tuned for our next webinar. And a big thank you to the presenters and for those who have attended today. And we shall see you next time.